We're ready for argument on Arnold v. Kotek, whenever you are.
May it please the court, Robert Koch on behalf of the state. It's important to emphasize at the outset that this is a facial challenge to the constitutionality of ballot measure 114. Plaintiffs thus bear the heavy burden to show that the law cannot be constitutionally applied in any scenario. Plaintiffs have failed to do so. That's because under the law, Oregonians remain free to use magazines with a capacity of 10 or fewer rounds. Anyone with a permit can initiate a firearm transfer, and anyone whose background check has cleared is free to complete their firearm transfer. My plan this afternoon is to follow the structure of our reply brief. Begin first by addressing the pertinent legal standard under Article 1, Section 27, then addressing each of the law's three components, the restriction on large capacity magazines, the permit to purchase requirements, and the closure of the Charleston loophole. And then if there's time or if the court has questions, I'm also, of course, happy to address the trial court's erroneous evidentiary rulings. Turning first to the legal standard, I think it's helpful to begin there because that's where the trial court's analysis got so far off track. The court invoked an intermediate scrutiny standard of review for the law that has no basis in Oregon law.
So what is our standard of review?
Under Christian, the Oregon Supreme Court made clear that the pertinent legal standard is one of reasonableness, that laws...
Our standard of review, the Court of Appeals, to review what the trial court did. What is our standard of review?
For legal error. So the court examines the facial constitutionality anew.
Okay.
Because the constitutionality of the law presents questions of law, whether the voters enacted a reasonable regulation, and that presents a question of law, which this court then reviews anew, and there's no deference given to the trial court.
Right. And so then with the next question I have is, given that is our standard of review, the ultimate question is whether the ballot measure is constitutional. What is the legal framework we use to determine that question?
The legal framework, Your Honor, is provided by Christian, which is whether the law is reasonable, whether it reasonably promotes public safety without unduly frustrating the right to armed self-defense. So inherent in that analysis, inherent in that legal standard is you look at what is the harm that the law was enacted to prevent, or what's the scope of the harm that each of the provisions was enacted to prevent. Do those provisions reasonably relate to that stated harm? And do they unduly frustrate the right to armed self-defense?
And so it's the state's position that the question is if the provisions reasonably relate to the stated goal. So here you would say, do these provisions reasonably relate to public safety? Correct,
Your Honor. And then as part of that reasonableness analysis, you examine whether in relating to that protection of public safety, is the right to armed self-defense unduly frustrated?
Right. So we have a legal error standard of review under the state's theory. The question we're asking is the question from Christian, whether the regulation is reasonable to promote public safety without unduly frustrating the constitutional right to bear arms. What, if any, then relevance do the trial court's factual findings have in this case? What facts are critical for us and what facts don't matter, if any, don't matter?
Well, Your Honor, I don't believe that the trial court, to the extent that the trial court made factual findings, it did so as part of the legal determination of whether the law was facially constitutional. And so I don't believe that there are any factual it's unclear whether, I wouldn't say that there were even factual findings that are necessarily need to be reviewed. And so to the extent that the court didn't really make credibility determinations, and frankly, Oregon Supreme Court case law makes clear that the facial constitutionality of a law does not depend on adjudicative facts. There's not something on which there are factual findings made. To the extent factual determinations ever come to play on constitutionality, that happens in an as-applied challenge. But this is a facial challenge.
Right. I mean, so is your position that the trial court really didn't make factual findings at all?
Well,
because there's a whole lot of opinion there that seems to be a lot of fact-finding. I mean, there were what? It was 6 days of testimony? So out of that, there comes no factual findings?
Not any that warrant deference in the context of.
So that's a different, I think that's a different question. So you would say that there were fact findings made, but your position is, the state's position is that this court doesn't have to defer to them?
That's correct.
Okay.
Particularly in the context of a facial challenge.
Right.
Which is what this is. Yep.
Right. I understand that.
And I think to also answer your question about what's the legal standard that this court applies under Article 1, Section 27, there is also the threshold legal question of whether the law regulates a protected arm, whether Article 1, Section 27 even comes into play because the weapon that's being regulated is protected under the Constitution. And I point this court to its decision in Oregon State Shooting Association, which delineated a 3-part test for whether a weapon is even a protected arms under the Constitution. And in order to be protected, a weapon has to be of the sort that was commonly used for self-defense at the time of statehood in 1859.
Before we move on to that part, I do have one more question on my sort of pathway here. Is our review of the fact findings de novo because this is a declaratory judgment case in equity? Or do you ground the de novo review somewhere else?
So to the extent that there are factual findings that the trial court made that this court wants to assess, it is our position that you would take de novo review of that because it is an equity.
Okay, so it is because it's an equity. It's not because it's a facial constitutional challenge. It's because of the way it was litigated.
Well, so the second part to my answer is that because it's a facial challenge, we don't think that there are factual determinations that the court reviews with any deference. When the court has talked about, I would point to the Supreme Court's decision, particularly in Payless drugstores and in federal cartridge, which talked about when you're looking at a facial challenge, you're not examining adjudicative facts. The court is just examining the facial constitutionality of a law and whether it can be applied constitutionally in any scenario. And so that doesn't typically involve fact. And the Supreme Court has made clear that trial courts are free to hold evidentiary hearings to take evidence that may bear on the constitutionality of a law. And the trial court referred to the 6-day proceedings below as a trial, but it was really more akin to an evidentiary hearing in which it took evidence. But this court is also not bound by that. On facial challenges, the court can consider whatever facts that it deems relevant to the legal questions that are before it. We think that the record below is more than sufficient to conclude that the law is facially constitutional, that each of the 3 provisions are reasonable. But this court is also not bound by whatever was admitted into the record, which is why we don't think that the court has to address 5 of our 6 assignments of error. We think that the trial court made clearly erroneous evidentiary rulings, but the court can consider the evidence that was proffered regardless of those rulings. Turning first to the law's restrictions on large capacity magazines, it's our position that those restrictions are facially constitutional for 2 separate reasons. First, modern day large capacity magazines are not arms protected under Article 1, Section 27. This court's decision in Oregon State Shooting Association controls on that legal determination. Separately, even if they were protected under Article 1, Section 27, the restrictions are reasonable. As I mentioned before, to constitute an arm protected by the Constitution, a weapon had to be of the sort that was commonly used for self-defense in 1859. Modern-day large-capacity magazines were not. They're not weapons in and of themselves, and there was nothing like them.
Components of weapons, though, are they not?
Excuse me, Your Honor?
They're components of weapons, though, right? Aren't we kind of?
Certainly, a magazine is a component of a weapon, but large-capacity magazines in and of themselves are not necessarily a component of a weapon. You can have a capacity-compliant magazine to feed ammunition into a firearm, and so there's nothing about a large-capacity magazine that is necessary for any firearm to function. In fact, it's any firearm that accepts a large-capacity magazine, virtually every single one will accept a capacity-compliant magazine. Which is partly why the restrictions are reasonable, because they don't unduly frustrate the right to armed self-defense, because you just need only have a capacity-compliant magazine to continue using your firearm. And I've cut into my rebuttal time, so unless there are any additional questions at the moment, I'm happy to save.
There were weapons that existed back in 1859 that were capable of shooting more than one bolt, and you'd have to click the bolt every time, right? I mean, this isn't something that's brand new. The technology certainly is better today, but weapons used in the Civil War, for example, were capable of shooting from two different barrels, even different bullets, more than, one at a time, right?
That's correct, Your Honor. And so I think that's where it's an important distinction between a capacity-compliant magazine of 10 or fewer rounds and a large-capacity magazine, which is more than 10. And that's because in the 1850s, the capacity of a firearm was limited by its dimensionality. Because of the technology that existed at the time, the size of a firearm limited how many rounds it could fire. And the most at the time that was in common use for self-defense were pepper box pistols and Colt revolvers, which had a capacity between 4 and 8 rounds. And in Oregon, we were at the end of the nation's supply chain at the time. The most commonly used weapon for self-defense was a single-shot flintlock rifle. Contrast that with a modern-day large-capacity magazine, which only evolved because of 3 separate technological innovations in the 1880s, 2 of them for military purposes. And as this court made clear in Oregon State Shooting Association, military developments that came out after the time of statehood don't qualify under Article 1, Section 27 because it's not personal self-defense. And to contrast the two, you look at to reload, even if you had a Colt revolver or a pepper box pistol with 4 to 8 rounds in 1859, it would take minutes to reload because you individually had to load primer, propellant, and projectile into each barrel or chamber. To contrast that, I point this court to Las Vegas, the Route 91 Music Festival. A single shooter shot more than 1,000 rounds into a crowd of concertgoers in the span of 11 minutes. In one 60-second span, he shot 298 rounds, ultimately killing 58 and injuring more than 800. Those are very distinct technologies, and military-type weaponry, like a modern-day large-capacity magazine, does not qualify for constitutional protection. I'll save the remainder of my time for rebuttal.
Good afternoon, Your Honors. Counsel, may it please the court. Plaintiffs have 3 main points that they would like to address. The first is that defendants assert that this case only calls for conclusions of law. Article 1, Section 27, the constitutional provision at issue, and the Christian case, which is the test at issue, require findings of facts. For instance, whether an arm is protected or not is an inherently fact-based inquiry, as is whether a law furthers public safety and whether the law infringes or unduly burdens upon the right to keep and bear arms.
So what do you think our standard of review is?
Your standard of review, as the Muzzy case says, is where there's issues of fact, where the trial court found findings of fact. The issue is any evidence on the record. Where there are conclusions of law, especially the application of law to fact. In those instances, the review is for legal error.
What do we do with the fact that this case is seeking declaratory relief in the form of an injunction, and that if a declaratory relief action sounds in equity, we often take de novo review?
The court is not required to take de novo review. Defendants, appellants in this case did not request it. Also, the factors from the Oregon Rules of Appellate Procedure counsel against de novo review in this instance. For instance, the trial court made numerous express findings of fact, including several credibility determinations for expert witnesses and other witnesses. The opinion comports with those factual findings. The trial court was alerted to fact issues presented by the parties by pretrial memoranda. Defendants do not request or support any new findings of fact, and defendants allege evidentiary errors, most of which were invited by defendants.
So if our standard of review is as you say it is, then what do you think the legal framework we use to analyze the constitutionality is?
So plaintiffs have, and the trial court concluded that there's a 5-step test. The first is to determine, the first 2 steps determine whether Article 1, Section 27 applies. So first, it's a legal conclusion. Does the law apply to self-defense scenarios? Laws where the law does not apply to self-defense would be, for instance, hunting laws. You can regulate the number of shells that are allowed to be in a shotgun for the purposes of hunting, because that does not bear on armed self-defense or defense of the state. The next step is the protected arms question. After the court determines that Article 1, Section 27 applies, there's a 3-step analysis that comes. Plaintiff's test as proposed comes verbatim from the Christian case at page 38. The legislature may specifically regulate manner of possession and use of protected weapons to promote public safety, as long as the exercise of that authority does not unduly frustrate the right to bear arms. Elsewhere in that opinion, it says infringe.
Okay. So is it your position that every finding of fact the trial court made is important?
Yes.
What in our law says that the state must prove as a matter of fact that the law will in fact promote public safety?
Yeah, so there's not a lot of case law stating what kind of evidence is required there. Most laws are not like this law. They are specifically aimed at dangerous practices or practices that have been recognized historically as dangerous, such as concealed carry, such as firing within towns. And so, or they're aimed at, they exclude self-defense as a matter of law. So I believe it's in the Kessler case, they talk about a New York case where it said you cannot fire a firearm within a town. Well, that's a manner of use, using the firearm within a town, but it exempted self-defense. So here it wouldn't apply at all because self-defense is not affected. It would only apply to recreational uses of firearms.
So is your position that we don't have an explicit holding that you in fact must prove it promotes public safety, but that that's somehow implicit in the question that's being asked?
I'm sorry, no, that comes from Hirsch Friend. It's quoted in the brief, the exact quote, but what the Supreme Court said in that case is that the law must satisfy the purpose that it claims to further, in this case, public safety. So here.
So you're reading that language, the law must satisfy the purpose, to say that there's an affirmative burden on the state to prove that in fact it does?
Correct, Your Honor, because plaintiff's position is that it does not further public safety, and that was a finding of fact by the trial court as well, hearing testimony from law enforcement officers. And so then the burden would shift to defendants after plaintiffs have carried their burden of showing that the law does not further public safety to disprove plaintiff's evidence. And here defendants failed to do so.
So if we accepted your position, then in any case, the person seeking, the state seeking to uphold a law enacted by the people, either through the legislature or through a ballot measure, would have to prove that the law does the thing that the people hoped it would.
I'm sorry, Your Honor, let me try again here because I'm
No,
obviously
I'm
missing.
asking, is that wrong? You're not saying that?
That's not our position.
Okay.
In this case, the law is not aimed at any dangerous practice.
Well,
It's not aimed at any dangerous.
isn't it, though? I mean, isn't the idea of the permit and the completion of the check, the goal is to make sure that people who shouldn't have firearms don't have them? Am I wrong on that?
So insofar as, so the legislature, or I'm sorry, the Supreme Court has put a really narrow scope around who you're able to restrict, who the government is allowed to restrict from accessing firearms.
Right.
And those are certain people
Right.
who have been designated as dangerous, a dangerous person in this instance. So a dangerous practice or person must be regulated. And then the state does not have to carry that burden. They have not done so in this case. There's nothing in ballot measure 114 that is unique to people who have been convicted of felonies or have mental health issues or anything like that. It's aimed at all Oregonians. So for instance, a law that prohibits felons from accessing firearms, that's okay, because the legislature has designated a certain class of persons as inherently dangerous.
But isn't the purpose of the inquiry, the background check that's done to figure out who those folks are so that they're not given the permit to purchase?
Yeah, so we already have background checks at the point of sale in the state of Oregon and in all 50 states in the United States. It's actually federal law that you have to go through a background check. This is a second background check. Prophylaxis upon prophylaxis. It's unnecessary. It's identical in all ways except for the FBI fingerprint background check. And so, yes, we already have background checks in the state of Oregon, and the permit to purchase, its primary aim is not a background check that's already accomplished. It's about requiring all Oregonians to go through some kind of training in order to access firearms. And there's no Supreme Court case law or other case law that gives the legislature or here the people the authority to designate all Oregonians as inherently dangerous persons unless or until they disprove that by going through some kind of training. Basically, you're presumed guilty or unfit until you prove otherwise to the government.
So the standard here is it's unduly frustrate the right to have arms, right? Correct?
Unduly burden or infringe. And yes, there has been unduly frustrate.
Okay.
It's all three of them.
Okay. And it's obviously, you're here, it's your position that this is an undue burden.
Yes, Your Honor. If you get that far in the test, yes. More importantly, it's not a manner of possession or use restriction at all. It does not aim at any dangerous practice or dangerous person.
In your view, because it doesn't specifically focus on those, I dislike this phrase. I dislike the phrase those people, but it doesn't specifically focus on dangerous persons.
Correct, Your Honor. So hypothetically, if Oregon wanted to create a pathway back to having your firearm rights restored and require you to go through training because you were a felon, that would pass constitutional muster because it is a group of persons that the legislature has designated as inherently dangerous people due to their past violence. And it's also not limited to felons. That's just the easy category. It's also domestic abusers and other categories.
How does your logic apply to what I guess is called the Charleston loophole, the completion of things rather than initiation?
Yes, Your Honor. So there is nothing inherently unconstitutional about going through a background check. The problem here is that there's two indefinite timelines, and Oregonians cannot purchase a firearm until that background check is completed. There's a relief valve prescribed in federal law and Oregon law previous to ballot measure 114 that allowed but did not require the federally licensed firearm dealer to release the firearm to the purchaser if the state could not timely do their background checks. Oregon required, I believe it was a next business day, rule. The federal law, which is the applicable law, is a 3-day rule. So here, the court may someday be tasked with the question of how long until it's an undue burden. But here we're dealing with 2 indefinite delays on a facial challenge.
That depends, the determination that the delay is indefinite depends on fact findings the trial court made.
No, Your Honor. So the trial court ruled that the completed background check provisions could not be severed under 2 provisions of RS 174.040. I believe it was 2 and 3, but I'm going from rote here. And the defendants did not assign error to one of those 2. So it was a severability issue. So the trial court decided that the completed background check provisions could not be severed from the permit to purchase provisions.
So there was no separate finding of, okay.
The trial court actually excluded evidence that plaintiffs intended to proffer about how long it actually takes for a background check to be completed, and more importantly, for how the process works on the back end for FICS, FICS. Our evidence would have confirmed that there's 2 indefinite timelines created without the relief valve of the completed background, the pre.
And it's the indefiniteness that the client's position is the indefiniteness of the time period is what
Correct,
gets it,
Your
not
Honor.
the existence of a time, not the existence of a time period, and not the fact that it would need to be completed, not initiated.
Correct, Your Honor. And the big thing here is that the completed background check provisions before, it was not a state issue. People actually couldn't maintain lawsuits because the state was not preventing the person from accessing the firearm. The federally licensed firearm dealer, the FFL, was the one who had that decision. So the state was taking, in some instances, years to process background checks. And under the ballot measure 114, no person would be able to get a firearm if they were delayed. Pre-ballot measure 114, it was a 3-day rule on it.
How is that unconstitutional as as a facial challenge though? Because that all seems very much as applied, right? As applied, this is going to be indefinite. As applied, this is going to take too long. As applied to me, you can't complete my background check timely. Why is that on its face though? The ballot measure doesn't say, we have a huge backlog and we won't do your background checks.
Correct, Your Honor. So it's what time period is allowed, okay? And so normally there's a due process date. For instance, for the permit to purchase, it's 30 days. That's when, if you're not issued your permit at 30 days. So courts have looked at those types of laws in First Amendment cases as well, as a host of other types of cases where the period of time of delay is an issue. We don't assume on a facial challenge that it'll be instant, nor do we assume it'll take as long as 2 years in the instance of one gentleman.
Right, because the question is it capable of a constitutional construction in any event? So, that's right on its face. Could you construe it constitutionally?
And so here, on its face, the law allows for an indefinite period of time. There's no cutoff date. So anyone who does not have their background check timely processed would be unable to seek relief. And so that's kind of a side issue of what the trial court found, but that
Able to seek relief on an as-applied basis, that as applied to them, it was an undue burden on their right to bear arms?
So under the previous law, no, because it was not a state decision, it was not a government decision whether or not to release the firearm. The 3-day rule was intact. Post 3-day rule, there is no provision that allows, so I talk about 2 indefinite timelines. The first is how long it takes for FICS to look at the information once a person challenges the denial, once they challenge the delay. What our excluded evidence at trial would have confirmed is that the only due process is once there's an actual denial, not a delay. So there is no procedure in the law to challenge a delay. FICS just says we cannot determine whether to approve or deny this background check. And so it allows, they call it bucket 2 at Fix. It allows you to sit in bucket 2 indefinitely without any recourse. There's no statutory right to challenge it. It's not an other than contested case like there is with a denial. An other than contested case is how you challenge a denial, but there's nothing to challenge a delay. My time has expired. Are there any more questions?
I don't think so.
Thank you, Your Honors.
Thank you. Will you add a minute to the state's time, please?
I wanted to address 3 things quickly. The first was just to clarify the legal standard, and I want to point this court to Christian 354 Oregon at 33, where the Supreme Court expressly held that the Constitution permits, quote, reasonable regulations to promote public safety as long as an enactment does not unduly frustrate the individual right to bear arms for the purpose of self-defense. There's no support for some 5-step legal determination. The second point I wanted to address is with respect to this court's standard of review, the idea of whether there were factual findings by the trial court. This is a facial challenge, as the Payless case I mentioned earlier made clear by the Supreme Court. Facial challenges don't involve adjudicative facts. Also, the court can consider any evidence that was before, because the court generally can consider any evidence that was before the legislative body in passing the law. Here, that was the voters, so the court is also free to look at the preamble to the measure, which makes a lot of public safety findings. The court can also look to the voters pamphlet, which is Exhibit 103. All of those support the arguments that we have raised. I also want to highlight that there weren't disputes of relevant facts. To the extent that the trial court made findings, there was no dispute over any fact that we consider relevant to the legal determination. There was no dispute that there was nothing like a large capacity magazine commonly used for self-defense at the time of statehood. The trial court said, well, one existed in the world, that's enough. And this court's decision in Oregon State Shooting Association expressly says otherwise. And finally,
State's view, some of what's being identified as findings of fact are legal conclusions? Is that what you're arguing?
that's correct. So to the extent there was a dispute, it was an ultimate legal determination. That's correct, Your Honor. And then finally, plaintiffs argue whether Measure 114 promotes public safety. And I want to highlight the large capacity magazine restrictions. The defining feature of a large capacity magazine is the ability to fire more than 10 rounds without having to pause to reload. In mass shooting events, that means more shots fired, more injuries, more deaths. Restricting them lowers the number of shots, reduces the number of injuries and fatalities. We saw that in the Gabby Gifford shooting, in the Poway Synagogue shooting, and at Sandy Hook, where 11 first graders were able to hide or flee to safety because the shooter had to pause to reload. That pause can save lives, and it was reasonable that the voters of Oregon chose to require one here. Thank you, Your Honors.
Thank you. Thank you both. The case is submitted, and we will take a brief recess.